Judgment in the matter of Andrysiewicz against Circuit Court in Lodz, Poland.
In circumstances where a person's extradition is sought in order to serve a prison sentence imposed by a court in the requesting state, when considering the impact of extradition on the individual's right to respect for the private and family life under Article 8 of the European Convention on Human Rights, what weight, if any, should attach to the possibility of their release on license under early release provisions in the law of the requesting state? In Poland, the Penal Code grants the Polish courts a discretion to release offenders from prison before they've served the entirety of their sentence, if there's a justifiable assumption that the offender will respect the legal order after release. Any release of the offender will be on probationary license, which may be accompanied by license conditions which the Polish court considers it appropriate to impose for the benefit of the offender and the public. This appeal is about whether the existence of that Polish discretionary early release system, or similar systems in other states, affect the approach which the United Kingdom courts must take when a person opposes their extradition on Article 8 grounds. In the United Kingdom, judges must discharge a person if their extradition would be incompatible with the European Convention on Human Rights. In most cases, extradition will, by its nature, interfere with a person's Article 8 right to respect for their private and family life, but will usually be justifiable as a necessary and proportionate interference. The question is, therefore, whether the proportionality of that interference is affected by the possibility that, on return, the person may be imprisoned for less than the full length of their sentence, or even that they may not be imprisoned at all. In this case, a Polish court issued an arrest warrant for the extradition of the appellant, Ewa Andrysiewicz, on the 23rd of September 2020. The Polish court had convicted and sentenced her to 2 years' imprisonment for 4 connected fraud offences which she committed between 2007 and 2008. Her penalty was initially suspended for 5 years, but then ordered to be served in full because of her failure to comply with the conditions of suspension. The appellant was arrested in London on the 21st of January 2023 and remanded in custody the same day. An order for her extradition was made on the 23rd of May 2023, which she appealed on Article 8 grounds. In the High Court, Mr. Justice Swift dismissed her appeal, upholding the order for her extradition to Poland to serve the remainder of her sentence. By the time of her appeal to this court, the appellant had served the equivalent of her entire sentence in custody in the United Kingdom. As a result, the Polish judicial authority withdrew the extradition warrant and this court ordered her discharge. Nevertheless, this court decided to hear the appeal to clarify the issue of whether, and if so how, UK courts should take into account discretionary early release systems when ordering extradition. This question has arisen frequently in the lower courts, and inconsistent approaches have been adopted, making it appropriate for consideration by the Supreme Court. In a judgment by Lord Stevens and me, with which the other justices agree, the Supreme Court unanimously dismisses Ms. Andrysiewicz's appeal. The Court has been assisted in its consideration by the identification by Mr. Justice Swift of 3 possible approaches which might be taken to the issue. First, that any application for early release is solely a matter for the Polish courts, and UK judges can attach no weight to it in the Article 8 assessment. Secondly, that UK judges can acknowledge the existence of the Polish court's power to release on licence, but attribute little weight to it in the Article 8 assessment, except in rare cases. Or thirdly, that UK judges can assess the likely merits of an application to the Polish courts for early release and attach significant weight to the likely outcome in the Article 8 assessment. This court unanimously determines that the second approach is the correct one. Except in rare cases, the Article 8 assessment in extradition cases should take account only of the bare possibility of early release under the Polish Penal Code and attach little weight to it. First, this court notes that it is for the requesting state, in this case Poland, to decide matters of punishment and rehabilitation for itself where the offender has been found to have broken its laws. While the UK courts must discharge a person if their extradition would be incompatible with the European Convention on Human Rights, cases in which extradition would be incompatible with Article 8 will be rare. The public interest in extradition weighs very heavily in the proportionality assessment because of the critical importance both of giving effect to reciprocal international arrangements and of preventing disorder and crime. Any interference with the Article 8 rights of either the requested person or their family members must be exceptionally severe to outweigh the importance of extradition. The balance sheet of factors may also take into account the nature and the gravity of the offence and the delay since it was committed, but against these factors is the consideration that it is for the requesting state to set its own sentencing policy. Some states operate automatic systems of early release. Faced with an extradition request from such a state, a judge in the United Kingdom may be able to calculate with confidence how the early release system would operate in relation to the particular requested person. That system can then be taken into account in the Article 8 assessment and, in combination with other exceptionally compelling factors, in an extreme case could outweigh the public interest in extradition. However, even with automatic systems of early release, UK judges must still take into account that refusal to extradite deprives the requesting state of the opportunity to impose appropriate license conditions as part of the release. Discretionary systems of early release involve more complex questions. Under the Polish Penal Code, for the application for early release to be successful, the offender's attitude, personal attributes and features, lifestyle prior to carrying out the offence, the circumstances of the offence, and the offender's conduct after committing the offence and while serving the sentence must justify the assumption that the offender will respect the legal order after release and not re-offend. These are matters of which a UK judge will rarely have detailed knowledge. Even if the judge is presented with detailed evidence on each of these wide-ranging factors, they will still lack detailed knowledge of the methods of assessing and attaching weight to each factor and a contextual understanding of the relevant standards in Poland. Moreover, even if a UK judge could accurately predict that a Polish court would find there to be a justifiable assumption that the offender will respect the legal order after release, that finding is only the precondition to 4 subsequent exercises of discretion by the Polish court. First, the Polish court has a discretion as to whether to order early release at all. Secondly, when to order release. Thirdly, what license conditions to impose on the offender during the probationary period. And fourthly, what the length of the probationary period should be. These are matters which a UK judge cannot determine. A UK judge also lacks the ability to impose license conditions on the offender. They can decide only to extradite or to discharge the requested person. Given the range of options open to the Polish court, a UK judge may not be able to give effect to the likely outcome of a Polish early release application, even if they're able accurately to predict it. In any event, as a matter of international comity, the decision on early release is one for the Polish courts to make. It would be a breach of international comity if the UK courts, in dealing with extradition requests, effectively usurp decisions which fall to be made by the courts of the requesting state. In light of the difficulties in practice and in principle of predicting the outcome of a Polish early release application, this court rejects the third of the possible approaches summarized by the High Court. Ordinarily, it will not be appropriate for a UK judge to seek to assess the likely merits of an early release application, nor to attach significant weight to the prediction in the Article 8 assessment. However, this court also rejects the first approach. It is unrealistic for UK judges to ignore entirely the existence of an early release system when undertaking the Article 8 assessment. Instead, as outlined in the second approach, it will ordinarily be appropriate for a UK judge to take account of the bare possibility of release, but not to embark on predicting the likely outcome of an application by the particular requested person. That bare possibility adds little weight to the Article 8 assessment. In rare cases, however, it may be permissible for a UK judge to attribute greater weight to the predicted outcome in the Article 8 assessment. A rare case is one where there is agreed or uncontested evidence sufficient to demonstrate that the person would be released under the Polish Penal Code, when that release would take place, what the probation and license conditions would be, and that the inability of the UK courts to impose a probationary period with license conditions would not adversely affect the interests of the offender or the public. The court is now adjourned.